Hi guys, it's Kathy. I hope you're doing well. So we did it. We have enough on Facebook now to stream both to YouTube and Facebook. So I'm streaming both right now. Currently there's nobody on Facebook watching. However, if you do come to Facebook to watch, you should hop over to YouTube. YouTube is where it's at. You can still watch on Facebook if you want, but YouTube is where the best chat is and everything. So I'm just going to take a second to just make sure both of these streams are going okay. YouTube looks fine as always, and I'm not muted. Facebook. It looks fine. Hi, Lisi. Unfortunately, the bad part is I see both Facebook texts and I see YouTube texts at the same time, but you guys can't see them. This is a Facebook text. And yes, I did wear this shirt earlier because it's the same day. I'm not going to change 17 times a day. I'm going to change once, twice, three times maybe. Yeah, that was a whoops. It's fine. Who would know it's a whoops but you and I? Kelly's on Facebook. Don't say that out loud. Don't point out the whoops. Nobody saw it but me and you. Not one person. Hold on. Nobody. Nobody knows. Okay. Hi, guys. It's Kathy. I hope you're doing well. I'm just gonna cut that first part out. Will you stop talking about it? I'm trying to tell you nobody saw it but you and me. Nobody knew what they saw. You are pointing it out to everybody. Shh. All right. I have so much to show you today that I honestly don't know where to begin, and there's a cat in my way. I'm going to the. Uh, uh. All right, let's just do two cryings. Let's start crying. See? Nobody knows. Oh my god. I can't stand it. I can't stand him. All right. Nothing's muted. No muting.
Jason McLeod, class number 4017384.
I am not starting the day out with audio like that. I'm sorry. If you're going to have that audio, then no.
Well, just a moment. Mr. Glover will be right with you. So Taven Snyder, 24M989. Mr. Snyder appears on WebEx without authorization. Mr. Snyder, are you there?
Yes, ma'am.
Why are you on WebEx and not in person, sir?
I was in person. I checked in and I put on my phone at the store I was at, and I sent a message asking if I could just continue with WebEx. No one said anything, so I figured it was okay.
Are you at the courthouse?
No, I'm not right now. I had to go back to Home Depot to get my phone.
Okay, so you were here, but you left?
Yeah, I left my phone at the store I was at. Sorry.
Okay, well, it's an in-person appearance. If I set it over, do you understand that you do have to appear in person?
Yes, ma'am.
Okay.
Your Honor, just for the record,
Huh?
we would be objecting. We'd be asking for a bench warrant issue at this time.
I mean, I can.
I would note that there's been a pattern of failures to appear starting on April 17th, 2024, an FTA. On May 28th, 2024, he was not authorized to appear via WebEx, but did so. Again, on July 18th, another FTA. Most recently, December 9th, another FTA. And then today, appearing via WebEx.
I was in custody all those other times. I can come right back to the courthouse. Like,
Well, we're trying to get done with docket. We're still on our morning docket and we don't have an afternoon docket. What I'm going to do is I'm going to stay a bench warrant and I'm going to give you until Friday, January 3rd to come to court.
All right.
And that's going to be by 9 a.m. And you have to be in person or a bench warrant will issue, okay?
All right.
Okay, and we're on the third floor, courtroom 300, Friday, January 3rd at 9 a.m. Okay?
All right. Thank you. Bye.
Right, we call it.
Yep, he's going to jail. I think he's going to jail. So I'm working on it, Fozzie. I am working on it. Okay. Let's go to. I just have too much today, guys. And there's this judge is like, you know what? It's not my job. Not my job.
The 3990 case. It looks like he's still on summons in that case.
May
I'm sorry, did you have a question?
Yes, ma'am. We were trying to set my bonds because I was trying to get into Harvest Farms. I had a bed assigned to get into Harvest Farms.
Sir, hold on. Let me sort of try and clarify things.
Sure, Mr. Cotaverde, my understanding that the PD was wanting to address the bond in the complaint to revoke. I'm not willing to do that. I think probably Judge Briggs needs to be the one to hear those. So you can certainly file a request for an emergency hearing in front of him, but I'm not willing to intervene in the case at this point.
Your Honor, it was my understanding that we were setting it onto today so that
Briggs can handle his own bonds. Yeah, I'm not going to handle his bonds for him when he doesn't feel like doing it. So he can, if he chose not to handle it yesterday, I'm not going to handle it for him today. So, okay.
It's not my job. Not my job to do what he doesn't want to do. That poor guy's sitting in jail because nobody wants to give him a bond. They just don't feel like it. No, you're not. People are lying on Facebook, guys. Okay. Can I just show you 6 minutes? So, you know how I show Judge Frost from Wisconsin, all right? And I always show him in divorces and some custody, but mostly divorces, all right? And it's always a train wreck. It's just always a dumpster fire. Remember the guy who mowed lawns and was going to be a presidential candidate and I don't know, moved and lived with his lived with his mom. It's dumpster fires, but they're awesome dumpster fires. I keep telling you, but this judge, he does so much more. He doesn't just do stupid hellbilly dumpster fires. This is him. I mean, this isn't the one I was going to show you before. The one I was going to show you was a full panel of lawyers, very, very, very technical. This is a happy medium. This is him just kicking back with a few lawyers. No peons like us involved. This is just him and some lawyers.
Secure and compel a.
And we haven't seen him in a while, and I miss him so much. So nothing bad happens here. Nothing crazy happens here. I'm just showing you Judge Frost does all kinds of things.
Deposition of a witness in a foreign jurisdiction, another state. I do think that it makes sense that Texas law meant for their other general rules for depositions and subpoenas to have some interplay. And I do also think I appropriately granted the order when I first got it, based on the fact that Rule 176 says when there's an objection to the time or place and it's timely made within the 3 days of getting the notice, that automatically stays the proceeding. That would be true here, because though there may be a variety of other objections that perhaps were or were not legitimate, there was at all times an objection to the time and place, both by RSM and by the petitioners in this action, the defendants in the Texas action. In other words, I appropriately stated from the 20th because there were those objections raised, again, within that time period after a letter rogatory was issued. So that's another basis that I should have at least temporarily stated. Again, even if that's the case, I'm not sure I'm the right court to preside over setting the appropriate day and time. I think Attorney Ayala is correct that there are some uniform law type circumstances that say I do have a role and the responsibility to supervise as it relates to the party, the witness within my jurisdiction.
He's talking about Texas, okay? So apparently there's a couple from Texas, and there's some Texas law and there's some Wisconsin law, and some of the lawyers want these people to go down to Texas and fix it, and the judge is like, nah, I'll just take care of it here. All right, that's good enough. I'll stop there. I will stop there. I just missed Judge Frost, and I wanted you guys to see him too. Kelly, I can see you on Facebook, but when I try to make you a mod on Facebook, you don't show up on the list of people I can make mods, and I don't know why. Let's go to child support. I love this judge. Love him.
Ms. Laura and Mr. Gordon.
Hi.
Yeah. And Mr. Gordon, were you here during the playing of the video?
I wasn't.
So are you guys in the same place?
Yeah.
Because I'm hearing you, Mr. Gordon, through other audio. You guys just be on the same device.
Oh, we can be on the same device?
Okay.
As long as it's safe.
Okay, yeah. Sorry, our son's daycare is closed this week for the holidays.
What does that mean?
But they don't have no daycare.
What does that mean? It's safe or not safe for the two of you to be on the same device?
Oh, okay. You can hang up.
Oh, just hang up.
Your phone's low. Sorry about that.
No problem. I will remove you.
Oh, he's gonna remove you.
Yeah, he's gone. He's toast.
Okay.
Okay.
Right there.
So are you living together?
No, we don't live together.
Okay.
We're together, but we don't live together.
He has full custody of his two daughters, and then I have my two daughters full time, and my oldest daughter is autistic. So it's a little too much when we have all of the kids together.
I can imagine. And so Emilio is
Emilio's the baby.
Yeah, he's the boy.
In this whole mix. Oh man.
Yeah.
4 older sisters. Oh, that is just brutal.
It's a lot.
Well, I mean, when he's a baby, it's fun because they want to be mommies.
Yeah.
But as soon as he wants some independence and stop bossing me around, he's gonna die.
Yeah.
Well, that and he's almost as big as 3 of them.
Yeah.
So.
Oh wow.
Yeah.
Okay.
We weren't quite sure what to start with. Mother indicates that when dad comes over and visits, it's typically at her place.
Right.
Okay.
So are you assisting with bills at her household?
I give her money when I can. I'm not working right now, but when I'm working, I give her what I can.
When were you last working?
I think last month. It was around last month. Like the last week of.
What happened to the job? Okay.
Yeah, it was a temp job anyways, but I got laid off.
Did you have other temp jobs before that?
Yeah.
I mean, is that traditionally what you do, is get temp jobs through
it just so happens that I've been looking for full-time work, but the only people that offer me work is temp jobs.
Okay. Mr. Racine, you want to consider a secret order?
Oh, what's that?
I don't know.
It's an order that you submit a certain amount of applications every week, and then you keep track of where you're applying for work.
Yeah.
The Sacramento Employment and Training Agency to assist you in looking for work.
Yeah.
Then I would have you come back every couple of months to see how you're doing on finding that job.
Okay, yeah, that sounds good.
Mr. Racine is not looking thrilled about that. You had employment, right?
Yeah.
No, I'm talking to Mr. Racine.
We do. So we had a 21 weekly pay period average, $18.50 an hour. It was through a staffing agency. I'm open to what the court suggests. It just seemed like we had a good baseline coming into the beginning of this month.
Are you coming to bug me? Sure. But I thought that I had done all through December. Swear?
Thank you.
Okay. She wants me to get a paycheck. I have to do timesheets. It's like, what? Wait,
Don't you have someone for that?
her. That's what she came in to make sure I wanted her to do it. No, when I first came on, I was keeping very close track of how many hours I worked every day. They said, stop it. You're on salary. Okay, sorry. That wasn't meant for you guys. Minimum is 10 applications a week. At least 2 need to be in person somewhere. I would suggest you wear a shirt that has sleeves on it, by the way.
Yeah, I will.
You need to register with the Sacramento Employment and Training Agency.
Hi, Brendan.
Apply with their recommendations. You need to go on the Cal Jobs website. Those are where all the state jobs are located. And by the way, Sacramento Employment and Training Agency has career centers all over Sacramento. So there's got to be one close to where you live.
March 24th.
We'll come back March 24th at 1:00 in the afternoon. I will order you to return.
Do you know what day that is by any chance?
Yeah, it's a Monday.
Okay.
And so that's for the secret compliance review and financial review. What you need to do is get the contact. You need to keep track of where you're looking for work. Those are going to be on contact logs the DCSS will send to you. If you don't get them or you lose them or whatever, on a plain pad of paper, you just keep track of every place you look for work, along with the name of anybody you talk to, phone number, email address, street address, whatever information you have, so DCSS can check with the.
No, that shirt used to be a collared shirt, but he put it on and went, bam! Ah, damn! Happened again.
The jobs where you applied to see how the application is going. You need to provide those contact logs to DCSS. And you need to do that by March the 21st, which is the Friday before. And then I'll order you to return either video or in person at the next hearing. And ma'am, you're not required to show up. You're welcome to, but Mr. Gordon, you are ordered to come back.
Okay.
right, good luck.
All right.
Happy New Year.
Thank you. Happy New Year.
Okay, bye-bye.
We're together, but we're not together, Judge.
Now,
But we are together. Yeah, Kelly, come on over. Come back home. Leave that Fred guy there. There's nobody there. It's just all YouTubers there. maybe soon. I gotta start boosting. It's gonna take me a bit. It's complicated, as Donald says. It's complicated. Drunken Smurf, I missed you. Welcome back. I think there was something yesterday. I said Drunken Smurf. We need Drunken Smurf, but now I can't remember why. It could have been today. I don't know what day it is. Someone else can tell me. Let's do a little landlord-tenant, and then we'll do a deadbeat.
Well,
No.
as far as any type of harassment goes, which I am going to counter sue and also get restraining orders over, I don't appreciate Mr. Sykes having Jose Flores to contact me when I'm out of state visiting a relative and make threats.
I don't know anything about any of that.
I know this has nothing to do with the current, but
Right, so it has nothing to do with the current. So if you, you're welcome to file any other suits that you wish to file. That doesn't have any relevance, I don't think.
But as far as any type of missing or stolen appliances, they've all broken down due to natural use.
Okay.
Which I disposed of because he refused to dispose of them. I'm not going to keep broken appliances where he's been notified of in a place to put another one at if he's not going to take care of it. If he's not going to take care of them, then I'm going to dispose of them and I'm going to get new ones.
And also, there was a stove that was already broken that he said was a backup stove. It even had a dead mouse in it, and it was out in the shed. We scrapped that. It was in the way. There was also a microwave in there. Also, did not work. Didn't even have the cord to it. If he wants to say we leave excessive stuff behind, what do you call that? That was there when Chris and I had moved in. I thought a shed was meant to be empty, able to store things. I guess not. I only ever used that shed one time. I couldn't put anything in it.
I know surgery sucks. You'll be okay. All right? Make sure that you come into Discord and give us updates when you can, or I will freaking worry. You'll be okay. It'll be fine.
So, yeah, it's just, I'm not going to let something that's broken sit there in the way when something else could be put in there.
Okay.
As far as the order,
Wait, so the refrigerator's in the garage?
The furnace is in the garage.
yes.
Where we told him where it would be at.
I thought the refrigerator stopped working though.
The original refrigerator.
The original refrigerator that was in there when I moved in, he replaced with that one. That one was too small, so I put a bigger one in. That's the one that he wants back. And that's where it's been sitting at since I moved it out to the garage.
And it's probably still sitting there.
You don't put a studio refrigerator in a one-bedroom house with a kid.
Okay.
Oh, Maria gave you donuts. Maria, you're so nice.
Is there anything else you'd like me to know?
As far as the upstairs bedroom goes, my son is autistic. So whatever was going on up there, he had behavioral issues. But we did make sure to have it cleaned up before leaving.
I did clean that area, I vacuumed it. And air freshened it. The only part of the house that didn't get vacuumed was the bedroom, living room, that was it. Because there was still small stuff laying around.
It's a one bedroom house. The only part I didn't vacuum was the bedroom and living room. Yeah, because there was damage to the bedroom. Damage.
That we couldn't get to.
Shelving, Randy had gotten his own wood and put up there as well, as far as any type of extra shelving, so that there could be space to put things. And as far as the fencing, we got it for free from a friend of mine down south. And we agreed to leave that. And actually, there were threats being made that if we didn't leave it, he was going to charge more money. So, caught in the bind. I'm like, you know what? We don't need it anyway. We can always get more from this person. So, it's fine. Now, whether or not he's...
So apparently, they moved into his house, one bedroom house, and he left a lot of stuff behind. And like she said, a microwave, but there was no cord to it. But he wanted to keep it because it might work someday. And a refrigerator, that broke, but he kept it. But then he got another refrigerator, but it was one of those little ones. It was one of those little ones for him. So they put his little one out in the garage and they bought a normal size one. And they're saying, look, okay, we're leaving, but we're taking the appliances because we bought those. They got rid of all of his appliances. Some of them they scrapped because they didn't work, like this microwave. Because it just didn't work, and the landlord wanted to keep it there.
Decides to use it, that's his
As far as the carpeting goes, that carpeting has been in that house since before she moved in, and he admitted to having dogs in that house, shitting, or excuse my language, pooping and pissing all over the floor before she moved in.
Mm-hmm.
Yeah.
That carpet was actually making my son sick. Because he hasn't been sick since he's been out of that house either.
Her son was in the hospital 6 times in 1 year.
Anything else you'd like me to know?
Well, I'm going to make it perfectly clear that if any more damage gets done, there will be corrective action taken.
Corrective
Again,
action.
I'm getting restraining orders.
Okay, I don't know what you mean by corrective action taken. I don't know that.
I'm tired of us being harassed.
Okay.
I'm tired.
Again.
There's no reason for it, and don't use other people to come after me or my child or anybody else.
Okay.
I'm going to make it clear.
Anything else you'd like me to know that actually relates to this case?
Well, he's not getting the appliances I currently own. Because I fought like crazy to pay them off. They are mine. They have been kept up.
Oh my gosh, you're right. He's a good guy.
And they're not used.
Mr. Mueller, anything else you'd like me to know?
Not that I can think of at this moment.
Okay. Mr. Sykes, I see you raising your hand. What else would you like me to know?
I would just like to have a rebuttal on the calling his work and harassing his boss.
Again, not relevant to this case.
Okay, well,
I understand it's being brought up.
sure.
My goal is to separate out what's relevant, what's not relevant. If there's a different suit brought, we can talk about a different thing, different day. But
Yeah, I don't, I maybe didn't keep real good track of the appliances. But a lot of what they're saying is just really stretching. I mean, they're lies, just plain out lies and exaggerations of the way they want to think. As far as, I don't know, it's just, the whole thing's confusing. If anything, I've learned a little bit. I am willing to take off the charge for the appliances. And one thing about the appliances, when I went over to check on the original refrigerator, it was packed. Refrigerators need room to breathe, and that's why the motor burned out. So there's that. I brought them over. The refrigerator I had, just a smaller refrigerator just to get them through. And they did leave that, but they put that in the garage. When I went in the garage, I opened it up, and the freezer was packed. Packed wall to wall with bags of meat. Okay, and so I thought, well, I'm not going to eat the meat. I kind of let it go for a week or so. When I went back, the meat was unfrozen. It was just dreadful. It was just a mess. It's still there. Just haven't had time to get that part of it cleaned out. It's just what I'm going to say now may not be relevant, but it does tie into the case as far as, as far as the washer and stuff goes. It worked when they moved in, but I've had other tenants just cram washers full and dryers, and they don't, as far as properly maintaining, especially with the refrigerator. I mean, if you could have seen the original refrigerator, it was jammed wall to wall.
Welcome to the 80s, guys. Is your refrigerator running? You better go catch it. How many people did you call and ask them that? How many prank calls did you make? Love you, Snoopy. We'll see you soon, okay? We'll see you in a couple hours. You'll just go to sleep and you'll come right back. I loved making prank phone calls. I did. I'm the one. I'm that person. Remember the Jersey Boys? Was it the Jersey Boys? The Jerky Boys? Who were the prank call people? The Jerky Boys? Or the Jersey Boys? Jerky. I'm going with Jerky until someone tells me I'm wrong. Which they will, don't worry.
Unable to breathe, and that's the reason it burned out. And I didn't have to take another refrigerator over, but I did. Other stuff, I mean, the pictures kind of tell the story, about the way they lived. So I'm not quite sure where to go anymore with this, but I am willing to take the charge, 1, 2, 3, 4 appliances at $200 each. So that would be what, $800 off of the total amount.
They don't know what that means now. When Lori says she lost her phone because of prank calling, means she wasn't allowed to call anybody else. We didn't actually lose phones in the 80s because they were like plugged into the wall.
I'll take that off if that helps at all, because I can't substantiate their claims about them going out. As far as the appliances that were left, like the original refrigerator, they could have called me and said, "Hey, Bill, are you going to come take this out?" Well, we never got a phone call. And what they did is they took it and apparently scrapped it along with stuff out of the garage, which if they say it was there when they moved in, then it was. I'm not making excuses for myself, but I've been in this business for over 20 years, and I've come across a lot of, things that I just can't let things go anymore, you know, and I apologize if I didn't keep better records and this and that, but, you know, it's just, getting me old, this business is starting to really wear on me. And, so, aside from that, you can make the determination on your own.
I was looking through as both of you.
So he basically just said there, fine, I'll take the appliances off this case. You know, they just owe me rent. You know, you got to pay rent, guys. I know it's crazy, but you got to pay rent.
Folks were talking related to the previous testimony. There was testimony about $1,300 in rent. Do you have a ledger as to what rent was paid, what wasn't paid, when it wasn't?
I think I have received books. You know, I didn't bring one with me.
Okay.
And also, too, one more thing. I gave them on the date of the 20th or 21st of our eviction hearing. I kind of foolishly gave them until, let's see, until like November 1st to stay there and get the stuff out of there. That was 20 days, or 30, I gave him 30 days. He was telling me that in 30 days he could do a better job of getting that place cleaned up a little bit more. But I did give them, I don't know if that's in your notes or not, but I did give them 30 days when I could have had them out the next day. And that was just an oversight on my part. Sometimes I've been accused of being an empath, empathetic with people, which I am, but I'm starting to get away from that. Unfortunately, it's changing my personality a little bit with some people. I did not vet, Randy, I went over one day to look at something at the thermostat, and here's Randy in there. That's okay, who are you? Oh, well, I'm a friend of Tabitha's, and I moved in. How come I didn't hear about this, Tabitha? You know, I think
So he evicted them. He gave them 2 months to get out. And during that time, they moved someone else in with them.
it's in the lease, and you're supposed to give notice of, new roommates or whatever. You never did. And at that point, I thought I took a lease over there for him to sign, and also a character not a lease, but a background check on him, which I never got. But when I finally did do a background check, I thought to myself, man, I wish I would have done a background check on this guy, you know, but I didn't. And that's my fault. But anyway, okay, well, I'm not sure, you know, where else to go with this, but okay.
Kyle, is Carter.
First of all, Randy had not moved in at that current time. He was helping me fix things that were going wrong that Mr. Sykes refused to fix. He told Randy that fixing the thermostat would fix the furnace. He never serviced the furnace. And the whole time I've been there, it went out for about 6 hours.
I would be the best squatter in the world, ever. Because once I got down, I could never get back up again. I would be a permanent squatter.
My son had to go to my mother's because it was getting cold. And I mentioned that in the last session. As far as that goes, again, he didn't want to fix it. He didn't want to fix anything.
No.
It took DCS to get him to fix a front porch light that had exposed wiring and was hanging down and had mildew. And also, when the DCS caseworker was questioning him on a claim that my son made, and it was a very serious one at that, she wanted to speak with him, and he was drunk. And she suggested that we leave as soon as possible. He began to harass the caseworkers in that case, and I got a point
Anything that's actually relevant to this case? It's not just you picking at each other about things you don't like?
Well, as far as lighting repairs, that's pretty legitimate.
Well, that's relevant to the case, but now we're getting into DCS allegations of people being drunk, and I don't frankly care about that right now. Anything relating to this?
And as far as he mentioned keys a while back, I have had to replace keys for him due to him losing them
Hi, Jim.
multiple times.
We should have to keep tolerating to keep making him keys because he keeps losing his keys.
I didn't even have to make them for myself when I was there.
If he can't get a key box to put his spare keys in, then he doesn't need to be a landlord. Okay.
I've never seen a landlord lose their keys so often.
All right, so here's what I'm going to find. As far as there had been an agreement that had been proposed, that agreement was contingent on certain conditions, no excessive junk to be hauled away, no damage to be repaired. That contingency was not met, so that agreement is not binding at this point. Therefore, what I'm finding, I looked back at the notes. There was testimony relating to $1,300 of rent that was due and owing as of the last hearing date. That was in October. The house was inhabited.
It was funny.
November. Therefore, an additional month of rent for November is appropriate, an additional $575. I look back and from what I can see, there was no indication in the contract relating to any security deposit that had been paid. So no security deposit would be applicable to any of these findings. Mr. Sykes is asking for $1,000 in labor for the state of the house, the work that has needed to be done. Given the information presented, there's no invoices presented, so it's left to me to use my reasoned judgment to determine how much is appropriate. The living room is obviously in a state of disrepair. There's stuff throughout the house, but based on my judgment, I'm going to award $400 for the state of the house and any cleaning that needs to be taken care of. I'm going to award as reasonable $300 for the flooring that Mr. Sykes testified to. The total that I'm finding in this case as applicable is $2,575 in damages. That is inclusive of rent and inclusive of any physical damages to the property. I'm not assessing damages or awarding judgment for any sort of speculative damages, any sort of damages that don't have support there too. I'm also not awarding damages for any sort of appliances because I don't think the testimony has been proven or the evidence is proven beyond a 50-50 that Mr. Sykes would be entitled to recover any sort of damages for appliances. Therefore, court's judgment is $2,575 in favor of the plaintiff, plus court costs and sheriff's fee. That judgment will vary to the rate of 8% per year pursuant to statute.
You got $2,000 out of it. $2,000. All right, guys. Nah, there's somebody there. There's one more person. Somebody showed up. There's one more person with you, Fred. Okay. This next one is a bit sad. Yeah, there's one more person, I'm telling you. You guys aren't listening. There's somebody with you. And they're still there. Okay. This next one is a bit sad. It's they're not getting charged with murder because they didn't actually murder anybody. It's what happened after that happened that they're in big trouble for. And I didn't get the whole thing. I didn't get the mom talking. I didn't get the witness statements. All I got is, no, there's one more. You're not two. I'm telling you, there's somebody with you guys. So, I didn't get the mom. I didn't get the lawyers. All I got are the closing statements and the judge. And the judge is great. And the prosecuting closing statement is great. It's sad. It's sad what happened. But it's interesting. And don't worry. As soon as we get through this, which is sad, I got something fun. I got something fun afterwards, okay? This is 30 minutes long, so if you don't want to watch something sad, then you're not going to cry. It's not so sad that you're going to sit there and bawl your eyes out. It's just, you know.
Any further evidence, Mr. Galvin? Arguments from the state with respect to sentencing, and I don't know if you want to do this one at a time or jointly. I'll leave that up to you.
Your Honor, I'm going to do it jointly. There'll be specific times where I'll maybe just talk about Mr. Sam or Miss Sam respectively, but I'll do it jointly.
Thank you, sir.
Your Honor, I just want to start off by just some things that stuck with me from the words in the letters from Kelly Taylor's sisters and the words from Mr. Johnson and Mrs. Johnson. Mrs. Johnson started off by saying the worst phone call that a parent could ever receive is the death of a child. And I couldn't agree more. And what makes that call even worse in this situation is that it wasn't just the death of a child. It was the fact that she was thrown on the side of the road like she was nothing, like she didn't matter. And I think in every single statement made today or in the letters, one of the worst things that this family is always going to have to deal with is the questions that they're never going to have answers to. Was Kelly alone when she died? Did Mr. or Mrs. Sam provide the drugs to Kelly? Was she revivable? And they're going to have to live with that. They'll never have answers to those questions. Kelly lived a different...
So, Kelly was an addict. And I think that she moved into their house to get help. They were helping her. It's a man and his sister that did this. His sister didn't live there, but as soon as the man walked in and found Kelly overdosed, he called his sister up and said, "What am I supposed to do?"
Type of lifestyle than most. She bounced around from place to place. She put her trust in other people, and she put her trust in Mr. Sam. And from what was said today, it seems like for a little bit, Mr. Sam upheld that trust. He helped her out. He was a so-called friend. But I'd argue that he was never a friend. I would argue that it was a means to his own end. His actions on March 20th of 2022 show that the act of throwing her on the side of the road is a selfish act. It's an act only for him. And he betrayed her trust. He stood up and said today that Kelly Taylor's wish was if anything had happened to her, that she be discarded on the side of the road. Now that statement is only coming from Mr. Sam, and we don't know if Kelly said that or not, but I would be surprised if anybody said that. And it kind of seems to be shifting the blame, in my opinion. And so not only did he betray her trust on March 20th, he's betraying her trust today. In the affidavit and in the police reports, Kelly Taylor was found by Mr. Sam on the 19th. He told officers that when he went in there, she was already dead. And he went in to his sister and he said, "Hey, we have a problem." And so at that point, that's when Mrs. Sam got involved as well. They told officers that no CPR was ever done. They did check a pulse and could not find one. And I think at some point, Mrs. Sam did tell Mr. Sam to call 911, but he didn't. But neither did Mrs. Sam. They Mr. Sam went and bought a trash can from Menards. He was having trouble getting Kelly Taylor into the back of the car. And so there's some little things in this that really stick out because it really shows how much he betrayed her trust and how much that he kind of planned. Like, this wasn't something that he was scared. There was a lot of time that went by and a lot of things that he did to make this happen. He put her in a trash can, threw her into the back of the car, and drove around into the late hours of the night on the 19th. And the whole time that he was doing that, Mrs. Sam was right there. Now, from both their statements in the interviews, they both said that Mrs. Sam didn't help put her in the trash can, didn't help put her in the car, but she watched. She saw all these events unfold. And she was in the car every step of the way up until they dumped Kelly Taylor's body on the side of the road. Not only did they drive around into the late hours of the 19th, they went home because they couldn't find a spot to put her. And they rested. They got back in the vehicle, went back out on the roadway, and finally found a spot where there were no cars coming, and just dumped her on the side of the road. And on the way home from that, they stopped and got Taco Bell. And that's the type of little things. The trash can, the going out and coming back home and resting, going out back again, stopping and getting Taco Bell. All these little things that just show that Mrs. Sam and Mr. Sam were thinking about one thing, and that was themselves. They never thought about Kelly Taylor. And now, looking at Mr. Sam's criminal history, there's a lengthy drug criminal history. And so if he knew, he knows what drugs does to somebody. And if he was really helping Kelly Taylor, he should have done more. He knows how it affects him. He knows how it probably affected her. In 1984, he was convicted of driving under the influence. In 2002, he was convicted of possession of controlled substance. Again, in 2002, he was convicted of dealing in cocaine. And not only that, but he was on probation, and he had 3 violations of probation in that case. In 2011, he was convicted of dealing in meth. And in 2023, he was convicted of possession of meth. And there was a violation of probation in that as well. And Your Honor, looking at Mrs. Sam's criminal history, there isn't any. And so from the outside looking in, it looks like she's an upstanding citizen. And I would argue that that's not the truth, because she had every single opportunity to call 911 herself. If there were drugs in the house, none of them were hers. If she was scared to get in trouble, she didn't have any part to play in it. She didn't let Kelly Taylor stay there. One time she told Mr. Sam to call 911 and then stood by and watched as Mr. Sam desecrated the body of Kelly Taylor. Your Honor, going through this case, all the actions were deplorable. They both have no consideration for human life.
He's about to say why they did this, why they put her where they put her. There's a reason why they did.
In my opinion, if they did, they would have done right by Kelly Taylor and called 911. In the case for Mr. Sam, the state would be asking that Mr. Sam gets an executed sentence of 1 year, so the maximum, and that he's taken into custody to death. And that's based on everything that we heard from Kelly Taylor's family, from the statements I've made, and from the records check for Mr. Sam. And think it's more than appropriate that he gets the maximum sentence all executed. In the case for Mrs. Sam, the state will also be asking for the maximum executed sentence of 1 year at the Elkhart County Jail to be taken in custody of that. Now, there's not the criminal history that Mr. Sam has, like we talked about before, but just the sheer lack of respect for Kelly Taylor and just standing by and watching all this take place over the course of hours is just a total disregard for your human life and should be sentenced accordingly. Thank you, Your Honor.
Thank you. Ms.
Oh, I missed it. He said they dumped her body on the side of the road because Kelly told him to. Kelly said, if I ever died, you can just dump my body on the side of the road. That way the police don't come after you. So they were just doing what she asked them to do. Yep. That's what they said. Okay. So, yes, it's only 1 year because they didn't murder her. This isn't a murder trial. They just, what is it? Desecration of body, I think is what it's called, or something like that. And that's a misdemeanor. And the maximum penalty is 1 year.
Robertson, I'll start with you.
Mr. Sam had no idea that Kelly had died until he went in the room because she had not come out. He called his sister in there to check in case he was wrong. And she did go. Him and Kelly had developed a strong relationship. He was trying to provide a safe place for her. He never expected that she would die on him. Although she had talked about committing suicide several times, he said, and that after her fiance, boyfriend, had died, she changed. And she just didn't care anymore. Now, she had used, she was on Xanax, and even though he didn't agree with her being on Xanax, he couldn't say anything because she was going to take the Xanax, and he didn't know whether it was prescribed or what. Of course, this isn't something that is going to be repeated at any point in his lifetime. It's nothing that is going to be repeated in either of their lifetime. He remembered after she died what she had said to him, that she just wanted him to put her on the side of the road so he wouldn't get in trouble. Neither one of them knew that it was a Class A misdemeanor. But he knew, just like she knew, that they wouldn't want the police involved in their business. She had not told him any address for any of her family. When he would mention her mother, she would get upset. She said her mother lived in Tennessee and that they did not get along. She mentioned her sister, but she never provided him with an address. She would get upset when he tried to talk to her about her family. When she died, he didn't think about contacting her family. But that wouldn't have done any good for him because he didn't have any addresses for her family. He was in a panic. He found that Someone had died in his house. A friend had died. So he did what she said, thinking.
Anybody know whose courtroom this is? Have you figured it out yet? Did you hear that truck go by? Look at it.
That he was avoiding trouble for himself. He did ultimately bury her, or put her body in a location where he thought that the police traveled frequently, and so they would find the body quickly. He didn't know, like I said, it was a criminal offense. He did not know what all drugs she had used. He did not know why she had died. He assumed it could be from a drug overdose. But he did grieve and mourn for her death.
It's Judge Cristofino's courtroom. It's Judge Cristofino.
Mr. Sam realized when the police approached him to talk to him that what he had done was criminal. He wasn't feeling the best about it in the first place. He wasn't feeling the best about it when Kelly had mentioned it to him. He just said, don't talk like that, don't talk like that. When she died, he mourned the loss of a friend, just as anybody would, even though he had taken the actions that he did. And he is remorseful, Your Honor. He regrets that he did what he did and that he involved his sister. They did not think, neither he nor Kelly nor Miss Sam, of what the next step was going to be after they buried her. I put her body at the location that they put it. That she would be found. That the police would want to know what happened. So he has been pondering, he has regretted his decision and had been pondering what he would have done after she died, constantly. It's a Class A misdemeanor. The legislature made it that. And we, although, you know, everybody is creeped out about it and thinking that Mr. Sam did or Miss Sam did anything, something heinous. I understand having talked to him. And I know he didn't make a good decision either, because in the frame of mind that Kelly was in, she wasn't even making good decisions. So for sentencing, we would ask that.
YouTube really does not like the words you guys are saying in chat. So I have to get rid of them, and I don't want to. Just misspell them. Just spell them any other way.
Mr. Sam, we put on probation with was a year suspended, we put on probation for a year, and be assessed court costs or whatever. If the court thinks that he needs a evaluation, he will do so. He doesn't have much money, doesn't really know what all would be expected of him. But he does know that it won't happen again. He does know about his background, that he did not use any drugs in the house. he did not agree with Kelly using any drugs, but she did. He will undergo drug testing on a regular basis over the year of time, and give back to the community by serving some cow weekends. But we just ask that you not send this message to him that Mr. Carson is asking him for. He understands. And that's all I have to say. Thank you.
Thank you, Ms. Robertson. Mr. Galvin.
Thank you, Your Honor. Your Honor, in beginning my remarks, I suppose I'll say that I don't think that it would be controversial or otherwise untoward to suggest that I believe all parties are in agreement today on the premise that this is a bit of an unusual case, one that involves a bit of unusual facts and the use of a relatively seldomly used and in that regard an unusual sin. I believe all parties are similarly in agreement on the premise that the factual circumstances surrounding this case are certainly beyond merely unfortunate. Frankly, this case involves a loss of human life, and anytime that is the case, there is unanimity and consensus that those situations are tragic. And while I acknowledge comments made by the state's witnesses, specifically Ms. Kelly Taylor's family members who are hurt and who are looking for somebody to hold to account, my task here today is to represent my client, Ms. Vicki Sam, in pursuit of a resolution that is, just in this case. And so with that said, Ms. Sam has been found guilty under Indiana Code Section 3545-19-3, failure to report human remains, Class A misdemeanor. And while our appellate...
That's what they're charged with. Failure to report human remains. It's a misdemeanor.
Court has instructed that aggravating and mitigating factors are not formally applied to misdemeanor sentencing insofar as the court is not under any obligation to specifically articulate and balance those factors. Nonetheless, I believe it would be instructive to point out a number of mitigators here today. So with regard to statutory mitigators, I would suggest that the following mitigators are applicable, specifically that, I would join in counsel's comments at this time.
Kelly wasn't their child. Kelly was his friend. That guy right there. That he was supposed to be helping. This is Judge Cristofino's courtroom.
Well, as a result of circumstances that are unlikely to occur, I believe that's very unlikely. I would point out that Ms. Sam has no criminal history, that she would be quite likely to respond affirmatively to probation or imprisonment. More on that in just a moment. With regard to case law mitigators, I would point to the remorse exhibited by Ms. Sam. Of course, Ms. Sam did plead guilty without the benefit of an agreed resolution. She pled open to the court. Ms. Sam has been gainfully employed at her current workplace for 16 years and is an otherwise productive member of society. Now, turning back briefly to my initial remarks, I suggested that this case involves the use of a somewhat unusual statute, and from my research, I have found just 5 reported decisions involving the statute under which my client, Ms. Sam, has been found guilty. I'm happy to provide citations to each of those cases for the court's consideration. I would caution the court that consulting those cases may potentially lead to a suboptimal foundation upon which the court may wish to construct its sentencing. In fact, 4 of those 5 reported decisions, involve charges of murder. The 5th and final of those cases involves a charge of level 1 felony neglect of a dependent resulting in death offense. Rather than looking to those cases for guidance, I would ask that this court base a sentencing decision primarily on the specific and unique circumstances involved in this case, influenced by the previously recited mitigating factors. And so to that end, I would ask the court in reaching a sentencing decision to place a particular emphasis on Ms. Sam's lack of any criminal history prior to this incident. I would also request that in reaching its decision, this court adopt a pragmatic approach in considering those circumstances involved in this case. Specifically, I would ask that the court remain mindful that while it certainly is no excuse that pardons her conduct, when Ms. Sam discovered Ms. Taylor, she was tasked with an incredibly stressful and an incredibly difficult decision on what to do. Ms. Sam unfortunately chose the path of inaction when she was confronted with an affirmative obligation to act. And that's something that she's going to live with for the rest of her life. With all of that said, accordingly, it's our position today, and I would urge the court today, to sentence Ms. Sam with a conscious pursuit toward the rehabilitative function of justice. And to that end, I'd ask that this court sentence Ms. Sam to a suspended sentence, one with a term of probation. With that, I would also request, and frankly, I would actually insist that any treatment and programming that are to be completed as a term of probation, that those include any kind of treatment or programming specifically, directed at addressing any potential mental health and or psychological disorders or abnormalities.
All right, thank you, Mr. Galvin. The court has considered all of the evidence presented today. I have reviewed records checked filed with respect to Mr. Sam. I have reviewed all of the letters that were tendered along with the records check. I have considered the letters that were read out loud today and considering the statements made by both Mr. Sam and Mrs. Sam. I'm also considering argument and statements made by counsel as well. Mr. Galvin is correct. This is a misdemeanor offense. Aggravating and mitigating circumstances are not something the court is required to do in this instance. This is a misdemeanor offense because the General Assembly said that this shall be a misdemeanor offense. That is not something that the judiciary has any control over. We don't make laws, we follow them. So if this were a situation where an enhanced charge or anything more egregious than a misdemeanor is appropriate, that is for the General Assembly to answer. That is not for the judiciary to answer. Again, we don't make laws, we follow them. The court's purview in this instance is under the guise of failure to report human remains as a Class A misdemeanor, and I will sentence as such. Mr. Sam, I'm going to start with you first, sir. You have a lengthy criminal history. You know that. I know that. Your lengthy criminal history includes multiple felony offenses for which you went to prison for. Your criminal history includes opportunities, several opportunities, and Mr. Carson was absolutely correct in his argument. Several moments where you knew what treatment options could potentially be available for this individual who you say you cared for. I heard no evidence today that you provided Kelly with any resource or treatment option available to help her overcome an addiction that seems to be at the very core of all of the circumstances before you became involved and dropped her body off at the side of the road. You are in a position of trust, sir. I find that to be an aggravating circumstance. Again, do I have to consider aggravators and mitigators? No. But I want you to understand why I'm crafting the sentence in the manner that I'm doing so. The harm, injury, and loss was significant, and other forms of sanctions have proved to be unsuccessful, specifically to you, Mr. Stan, from keeping you from engaging in criminal activity. That is an aggravating circumstance. You appear remorseful today. I will consider that to be a mitigating circumstance. The facts and circumstances surrounding this particular situation far exceed the elements for which the state needs to prove guilt beyond a reasonable doubt on this Class A misdemeanor. I find particularly troubling the length of time that you drove around with a body in your vehicle before you dropped her off and went to eat Taco Bell. Given the aggravating circumstances in this instance with respect to you, Mr. Sam, I am going to sentence you to 1 year Elkhart County Jail. I am executing all of that time. With respect to Ms. Sam, I recognize that you do not have a prior criminal history. I also recognize your acceptance of responsibility, albeit quite late. I find to be particularly egregious and far outside the elements necessary to prove the offense in this case. The fact that you drove around with your brother for a period of time, had multiple opportunities to find another way to give this person some dignity and respect. Because at the end of the day, we give humans dignity and respect. That is not something you did that day. At any point, you could have made a phone call, dropped Kelly off at a hospital, called the police, called the fire department, the EMT, any emergency responder. You knew that, and you didn't do it. I see that as no different from an individual who drives a getaway car. Having considered the aggravating and mitigating circumstances in your case, and again, I don't have to, but I want you to understand why I'm sentencing in the manner in which I am. I am sentencing you to 1 year Elkhart County Jail, and I am executing all of that time. I am ordering that both of you be remanded to the custody of the sheriff. I do need to read appellate rights at this time. You have the right to appeal the sentence imposed herein. In order to do so, you must file either a notice of appeal or a motion to correct error within 30 days of today's date. If you elect to file the motion to correct error and you fail to do so within 30 days, your right may be waived. Failure to comply with any of these requirements will result in the forfeiture of your right to appeal. You have a right to be represented by counsel at all stages of these proceedings, including any appeal which you may wish to pursue. If you are unable to afford an attorney, I am obligated to appoint one at no cost to you. Mr. Sam, do you understand your appellate rights as I have explained them to you?
Yes.
Ms. Sam, do you understand your appellate rights as I have explained them to you? Ms. Robertson, is there anything further that we need to address at this point?
No, Your Honor.
Mr. Galvin, anything further we need to address on your end, sir?
No, Your Honor.
With that, Mr. Carson, is there anything from the state's perspective?
No, Your Honor.
I am not imposing a fine. I will impose court costs only. Court costs will need to be paid by March 27th, 2025. That will be the order of the court. You are both now remanded to the custody of the sheriff. Thank you.
And they go to jail. She gave them the maximum by law that she was allowed to give them. She wasn't allowed to give them any more than the maximum. So, oh man, people these days, I don't get it. But Your Honor, she asked me to do that. She asked me to. Okay, that was sad. I told you it wasn't going to make you cry sad, but it was sad. Let's get away from that. Yes, because it was just not reporting a body to the police. That's the charge. Okay, some of you guys saw this today. Let me see how many. I'm going to tell you how many. It's just going to take me 2 seconds. So, earlier today we did a members only live. And 189 of you saw this earlier today. So now I'm going to play just a little bit for the rest of you, but not the whole thing. I did the whole thing in the members only clip. So if you want to see every second that I had, it's in the members only. But for this stream, I'm just going to play just a little bit, maybe one or two. It's a new judge, but I think he's just filling in, so we can't get him. I can't believe we've never seen him before. I've never seen him before, but maybe some of you have. He's amazing. I love him.
Asking that you grant the final judgment and decree that we've sent to the court.
All right, stop just for a second. I see Mr. Ollie up here. Mr. Ollie, do you have anything you want to share with the court?
Yes, sir.
All right, what you want to share?
I don't know. I got nothing. I was just.
You're not opposed to this divorce, are you?
No, sir.
Okay. Well, then, Happy New Year to both of them. I will grant you. I think you've sent the paperwork. Is that right, Ms. Gilkison?
Yes, Your Honor, I have. And like I said, the parties have nothing joint. There's nothing to divide. They each have their own stuff, and that's that.
All right, I'll get the order signed. I wish everybody the best of luck. Thank you.
Thank you, Your Honor. That concludes my business. May I be excused?
You may. You
All
may.
right. Thank you. Happy New Year.
Happy New Year. Now, I know some people get mad, but I'm going to do the lawyers first so they can get out of here and not continue to build their clients. Nothing wrong with that. But, all right, Mr. Bell, you've got the Miller, I think you started off with Miller Park Homeowners Association. Did Pamela Clark appear? All right, what you want to share with me, Mr. Bell?
Your Honor, I'd actually ask for a continuance on this one. We're trying to work on a consent judgment, and she just hadn't turned it.
Okay. I'm okay with that, so that's easy. That's one.
It's an easy one.
All right, and how about the next one? I see it looks like Mrs. Devontae. I may have mispronounced it.
Yes, good morning. You said it properly, Your Honor.
Thank you. Now, Mr. Bell, do y'all need to talk?
Your Honor, I'd rather just proceed on this one.
Okay. All right, Ms. Devontae, are you ready?
Yes.
Okay. All right, Mr. Bell, make your case, and I'll hear from Ms. Devontae.
Okay, I've got Mr. Miller. If you could unmute yourself, switch views real quick.
All right, no problem.
All right, can you raise your right hand for me, Mr. Miller?
Absolutely.
Do you swear or affirm the testimony given on the matter pending before the court is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can put your hand down and just let the court know your name and who you are.
My name is Zachariah Miller, and I am the current property manager for Keystone Gates.
In your role, are you familiar with the books and records of the association?
Yes.
Are you also familiar with the declaration recorded in, I believe, pull the right one up. Sorry, Your Honor, I had both of them pulled up in anticipation for it.
Take your time.
All right, it was filed here and recorded here in DeKalb County. Are you familiar with the declaration, Mr. Miller?
Yes.
All right, pursuant to Article 8 of the declaration, does each record owner of a lot within the community have an obligation to pay assessments?
Yes.
Also, pursuant to the declaration, if an owner does not pay assessments, does the association have the authority to levy late fees, interest, cost of collection, and also recoup reasonable attorney's fees actually incurred?
Yes.
And in your role, are you familiar with the account histories and ledgers for individual owners and their lots within the association?
Yes.
Is this monthly assessments or yearly assessments, semi-annual?
Monthly.
Okay. Do you know the amount right off the top of your head? Do you know the amount?
150.
Okay. Are you familiar with the account history for the defendants in this case?
Yes.
Have they paid all their assessments and charges levied against the lot?
No.
To date, how much in principal do the owners owe the association?
$6,969.55.
So hang on just a minute. How do you get that? If we're just dealing with the principal, how do you get if it's an odd number? I hate to ask you that question because I think counsel just asked you.
Like I said before, they just said it was $6,000. Remember that because it changes.
Principal amounts. I'm curious how you get such an odd number for 50 a month.
Mr. Miller, do you know what amounts go into the principal?
Yes, late fees, interest, and as of course the assessment.
All right, so this is okay. All right, go ahead, Counselor.
And I'm just gonna skip ahead, Mr. Miller. Has the association incurred attorney's fees for work done by my law firm?
Yes.
And can you just let the court know what the attorney's fees that have been incurred are and what the legal expenses and costs that have been incurred are?
It is attorney fees $2,256 even, and legal expense and costs of $555.43.
Your Honor, I don't have any more questions for Mr. Miller. I've obviously got my attorney fee statement I'm happy to go into.
All right, what are the costs? I presume a filing fee would be a couple of $100. So what are the other costs? Private process server?
Let me pull it up, Your Honor. Again, I had two of them pulled up ready to go.
That's all right.
Your Honor, you want me to just get my statement right now?
You don't have to. I'm just curious about I'm not objecting to the attorney's fees. I presume you charge a reasonable amount standard in the area of your practice. So I'm just curious. I'm always curious about the cost. That's all.
Your Honor, costs and expenses in this one, my law firm actually sends 3 letters to each defendant prior to filing a lawsuit. So you've got postage for those 3.
All right.
We do a couple of title searches before we send our first letter, before we file our complaint, just to make sure we're going after the right people. Do a bankruptcy search just to make sure we're not violating any sort of stay.
Okay.
Then once we get into a lawsuit, that's when your costs start ramping up, because the costs are the court costs. The expenses are really just mailing fees, postage.
I got that. I just thought the court cost a little 555. I've never heard that. But anyway,
Your Honor, the costs are not that high. We bundle the cost and the expense.
Okay, I got you. All right, Ms. Devontae, do you have any questions you would like to ask Mr. Miller?
Yes, Mr. Miller, I spoke with you, and we had discussed the fees, and I told you that I was going through Capriella and Zenner to pay the fees. We had made an agreement. And
I just asked the question. I'm going to let you testify. Do you have any questions to Mr. Miller, such as, Mr. Miller, did we make an agreement?
Mr. Miller, did we make an agreement?
I do not believe so. I'm not in the capacity to make an agreement.
Okay, go ahead, Ms. Devontae. What other questions?
Did you not tell me that you would put me on a payment plan, saying that I was on a payment plan so that I wouldn't incur any other fees? I'll give you the date that I spoke to you.
Don't worry about it. Let him answer the question.
Yeah.
I most likely sent that to the board for their approval.
So did they approve it?
No, they did not.
All right, Ms. Devontae.
That's all.
Okay,
Yes.
now then, Mr. Bell, any other questions you have? You want to call the other witnesses?
No other witnesses, Your Honor, and I can really quick speak to what Ms. Devontae is talking about. It should clear what she's about to say potentially up. I think she and another attorney from my firm appeared at a court hearing prior. I think they agreed on an amount to be paid per month. She has been paying. She never returned any sort of agreement signed. The one that she did return signed, she had changed the numbers on. So I think there may have been an agreement in principle, but nothing was ever signed by all parties, which put us back here before the court.
All right, but did you tell me she had been paying?
She has been paying.
One time.
Yeah.
Okay. All right, Ms. Devontae, raise your right hand, please. You swear firm testimony about to give the matter opinion before the court shall be the truth, the whole truth, the number of truth. Have you God?
Yes, help me God.
All right.
Thank you.
Now I'm going to ask you a couple of questions. Then after that, if you want to testify to anything else, you may. At some point in time, did you and counsel for the homeowners association think you'd reached an agreement?
Yes, sir.
Okay. And what was the total amount you would have paid on that agreement?
$450 a month.
Okay. Do you remember what the total amount was that you owed according to that
Yes.
agreement?
I have it here.
Okay.
Hold on for 1 second. It was $5,657.71.
Okay, now she says 5,000. They said 6,000. It changed to 11,000. So it's somewhere in that ballpark. Yeah, he is.
And this is from
So good.
the attorney's office.
All right. Now let me ask you this. You counsel say that they had sent you an agreement, but it was never returned and signed by you. Is that correct?
That is not correct. I did send it back. I have 2 sons, Your Honor, and my 2 sons were included in this lawsuit, which they don't live with me. They removed one of my sons, Darrell Devontes, off of the agreement letter that I signed. And then I spoke with Mr. Zenner, and Mr. Zenner said that he would send me another letter saying that he would be removing my son, Dijon Devontes, off of the agreement.
All right.
And then I never heard nothing back. I never got a letter stating that, and no, we did not sign anything.
All right. Did you send any more payments other than one-time $450?
Yes, sir. I just sent one. That was the other day.
Okay. Since you had your last hearing, how much have you paid on your assessment?
Yes, I'll tell you right now, sir. One moment. Let me see here. Okay, it's 450 times 9.
Okay.
4,050.
And Your Honor, if I could clarify one thing briefly.
Sure.
What Ms. Devontae just held up, I told you, remember we sent 3 letters before we filed.
I got that part.
She just held up the first letter. That was not the consent document.
Never, 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 never trust anybody who says 3 like this. This is not 3.
Document that she just held up. So
I'm okay with all that. I'm okay with all of this. I'm just curious. Can anybody give me information regarding her comment that she sent over $4,000 in the last 9 months?
She has, Your Honor. She has. But the total amount that was in the consent judgment was over $11,000, not $4,000, $5,000. So she still owes more under that. And we've actually followed up with her multiple times, including November 4th, just to simply say, if we have to go back to court, you're going to incur more fees, send us the signed agreement.
All right. So is it your proffer that y'all given her credit for the $4,000 and some odd dollars?
Yes, we have, Your Honor.
Okay. All right. Now, Ms. Devontae, what else you want to share with me?
Yes, sir. I never received another letter from them saying that they were going to take me to court. I wasn't even aware. I just got this letter in the mail saying that I had a court date. I never got nothing before that to inform me. Yes. And I've been paying my assessment, these fees as we agreed. So I don't know why I'm here. I'm still.
Okay, well, that's all right. Let me ask you this. You heard what counsel said. The original amount was over $10,000. Does that sound about right to you? In that original?
No, it shouldn't be. My fee was only $150 a month, even with the accrued lawyer's fees or whatever, which they have here. Let me see.
Well, the legal fees are in the ballpark. I'm gonna be honest with you. That's a pretty reasonable amount.
Okay, that's fine. That's fine. And then it comes up to this amount, $5,657. I paid $4,000 and something. I've been.
Well, according
they
to,
said it was $10,000. I don't know where the other thousands.
They said it was 11,000 or something. I'm not here to argue with anybody.
Yes.
Let me ask you this. Let me ask counsel this. Do you have any reason to be going after Dijon Devontae?
Your Honor, this wasn't my case originally. I'm fine removing them. I trust Miss Devontae's. That's the kids. I'm fine taking both of them out.
Okay. All right. Then any action is against Mrs. Devontae's. Okay. So both your sons are now removed from any order I execute. Okay.
Thank you.
Now I will give each of y'all, if you would like, 3 days to email to the court your proposed order and anything you want to attach to it, Mr. Bell, that shows what y'all's position is. Yes. And then Ms. Devontae, you got the same thing. You got 3 days in the day to email copies of letters and correspondence you have. But the reality is this, all right? A judgment is coming, all right? We all agree with that. We all agree, they agree, that you've been making $450 a month payments in an attempt to resolve this matter. The disagreement, obviously, is the amount that is owed. And you and I both know that if we don't pay something every month, it adds up and you get late fees. I don't know what they are. They're probably 25 or 50.
All right, this is Georgia, but it sounds like New Orleans. This is how people speak with a Cajun accent in New Orleans, and it's delicious and it's lovely.
$50. That's probably the standard rate of interest. And before you know it, 150 is 280 a month.
Right. So, can I answer a question, Your Honor? If I had a discussion with Mr. Miller and he said he would put me on a payment arrangement so that I wouldn't incur those fees.
I appreciate that. That's not before me. All right. I hate to tell you. He denied that he had authority to do that. Now, whether he did or not, it's not my place. All right. Now, I would suggest, quite frankly, when I cut you out, when the people that are running this machine terminate us, that you and Mr. Bell have a conversation. And if you can reach an agreement, fine. But here's the deal. If it's not signed by everybody, it's of no value. All right?
Right.
Yes. Give you a deed to the Brooklyn Bridge. It's of no value if it's just a quitclaim deed. So Mr. Bell is correct. If they sent you documents and you did not execute them for whatever reason, then you have no agreement. All right? You just have an offer. That's not the same. All right? Now, you got 3 days to submit me anything, but if I were in your shoes, I know it's New Year's Eve in a little while, and everybody's going to start drinking and celebrating.
I don't drink.
Well, that's good. I'm not getting it. I'm just making it.
Yes.
That's the only reason I became a senior judge, because nobody laughed at my jokes as a civilian, okay? So,
that chef that you don't remember the name of, I think it's Justin Wilson.
Y'all want to communicate with each other, you can. If not, 3 days, submit me something, I'll issue an order. But I'm not in the happiness business, okay?
I know.
The judgment business, all right?
Your Honor, if I could give Ms. Devontae's my direct line.
All right, Ms. Devontae, he's fixing to give you his direct line, and that's going to be, I presume, a telephone line. All right? But there are a bunch of bowl games on today. I know y'all not paying any attention to them, but I might be.
Are you ready, Ms. Devontae?
Yes, please.
And as soon as I get off this, I'm going to head into the office. So if you want to call me, leave a voicemail, I'll give you a call back.
I'll give you my number as well.
Well, let's share numbers across this line for everybody.
47.
Judge, can we get your number?
Yeah, no, I'm listed. Everybody calls me, so don't worry.
Okay, I'll call you.
All right, thanks, y'all. Good luck.
Thank you, Your Honor.
Thank you. Happy New Year, sir.
And if y'all, even if you can't reach an agreement, submit me an order.
Will do. Thank you, Your Honor. If we may be excused.
You may be excused. Thank you. All right. Is that
Unbelievable. Unbelievable. I said I wasn't going to do that today, and there I did it. I guarantee. Okay. That's all you get from him. That's it. That's all you get from him. If you want to see the rest of him, you got to go to the members only clip. I showed every second of him that I have. I want to just create a clip of him and take out everybody else talking and just do it. Just do what he said. It wouldn't make sense, but it would be amazing, wouldn't it? Anyway, no OJ today. For my birthday, my daughter and my nephew are taking me to see court. I'm going to a local courthouse today. I'm picking up my nephew shortly. He's not in Lancaster with me, so I have to go get him. And I'm going to be in the courthouse all day today. So I'm a little I'm a little worried about how much I have for a stream tomorrow. I'm not going to be here recording today. So we'll see. We'll see what happens tomorrow, but there is no OJ today. Yes, he's been in chat before. I think he was Winter 101. Winter 101. The whole docket today is domestic violence. It's the only docket that's running today. So that's where we're going. That's what we're going to see. It was the only day we could fit it in. And then after court, my the restaurant that I work at, we're still closed. We're not open yet. We're having our employee party tonight. So it's not my birthday. My birthday's gone. It passed. It's over. Let's forget about it. I see. We're not gonna forget about it. Oh, you shut up. Yes, 24. So yeah, tomorrow's stream is looking really shaky because I have my company party tonight, my restaurant party. We'll see. We'll see. We'll see what I can do. Thank you so much for coming out, guys. I appreciate it. Thank you. I haunt you. I'm level, yeah, my XP. I have enough XP. I'm 52. Nope. No, I'm not filming the party. Sorry, I have Facebook comments coming at me as well as YouTube. No, I'm not filming the party. Hell no, I'm not filming the party. I do have a designated driver, though, who is not going to film. What in the... Oh, I hate these cats. Okay. It was fun today. Yesterday. It's still today. So, no. No body cams. Bye, guys. I hope you guys have a great, great, great day. I'll talk to you all later.
Electric light, late night when the world sleeps. She's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Just right, even when my world turns gray. With a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no alarm. Screaming tales late into the night. Her laughter feels just right. Even when my world turns gray. With a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted charm. In a way, there's no